Hey everyone, welcome to this CCS interview series video on what's going on with the Notwithstanding Clause. And I'm really excited to be here with my friend Marion Sandilands, who's a partner with Conway Litigation in Ottawa. So Marion, thank you so much for being here today.
Thanks for having me, Richard.
Marion, I think it's fair to say that we are both extra keen observers of how things have been evolving with the Notwithstanding Clause in recent years, which has been keeping us pretty busy for a while. But we've just been through this really unusually busy week with a new invocation from Quebec, and then for the first time in about 25 years from Alberta as well. So, for anyone who hasn't been following these stories as closely as us, I guess us con law nerds, can you walk us through what happened during that very packed week at the end of October?
Sure, Richard. So a couple weeks ago, we had a first in Canadian history. It was the first time Section 33, so the Notwithstanding Clause, the first time it had been used in legislation in two different provinces in the same week. So that was Quebec and Alberta. I'll start with Quebec. So in Quebec, we had the passage of Bill 94, which was an act to reinforce laicity in the province. So it's an act that extends Bill 21 further into the education system. So Bill 21 is a law that prohibits the wearing of religious symbols for certain public servants, including teachers. So, for example, teachers can't wear the hijab or the kippah in Quebec, for example. So that was Bill 21. It was passed in 2019, and it used the Notwithstanding Clause preemptively and totally. And Bill 94 is kind of a next step for that rule. So it extends those types of rules further into the education system. So, for example, now not only is it teachers who are banned from wearing religious symbols, but also any employee at a public school, any contractor, or even any volunteer on school property is prohibited from wearing a religious symbol. Bill 94 also prohibits various types of religious accommodation, like days off, and it actually prohibits all religious practices on school property. So that's things like prayer at school. So that law was introduced back in March 2025. It went through the usual legislative process and it was adopted into law at the National Assembly on October 30th. And that law, just like Bill 21, has a notwithstanding clause in it, total, maximal use of the notwithstanding clause, as well as an override of the Quebec Charter. And I think it's actually kind of telling because the news reports on the day that it was adopted didn't even mention the presence of the notwithstanding clause in the law. So that was Quebec. And then Alberta, actually, it happened earlier in the week with Alberta. They used the notwithstanding clause to end a teacher's strike. So Alberta became the fourth province to use the notwithstanding clause since 2018. So as you mentioned, Alberta had used it only once before, back in 2000, but they hadn't used it at all in 25 years. But now they've joined the group of provinces that I'm calling sort of the new age of the notwithstanding clause, in using it now for the first time in sort of our recent history. Um, Bill 2 was enacted quickly. It was to end the 3-week long teacher strike. It's called the Back to School Act. So the purpose is pretty clear. It's to end the strike. What's interesting about this bill is that it was introduced and adopted at the legislature on the same day. So that is an extremely fast legislative process. It's pretty unusual. And what it does, it orders the teachers back to work and it imposes a collective agreement on the teachers. So that type of legislation, we've seen that before. But what's unusual about it here is that it also invokes the notwithstanding clause. So it's legislation passed quickly with a notwithstanding clause in it. That's pretty unusual. And we'll include links to both Bill 94 and Bill 2 in the description box below if you want to learn more about those bills. Another thing to watch that's happening also in Quebec, also around this time, was on October 9th, Quebec introduced Bill 1, which is called the Quebec Constitution Act 2025. Lots to study in that bill, and a big piece to watch for on rights and freedoms there. So Bill 1 allows for something called a parliamentary sovereignty clause. and it seems to say that the legislature can declare that a law is immune from any court challenge on rights and freedoms, period. This is a new thing we've never seen before, and Thomas Mulcair has called this the Notwithstanding Clause on steroids. There's a lot of other things in Bill 1 designed to make court challenges of government laws more difficult at various procedural and financial ways. So that's definitely something to watch for. It's working its way through the legislative process now in Quebec. So definitely one to watch for.
Wow. I mean, that was only my first question, and I think a lot of people's heads might be spinning after that already. So the notwithstanding clause, at the very least, I think, is a signal that a government is predicting that its law will be struck down by the courts for violating a right contained in Section 2 or Section 7 to 15 of the Charter. So the obvious question here is, if that is what Quebec and Alberta seem to be predicting, are they right in that prediction? Are there charter issues with these laws that would likely lead to judicial invalidation? And if there are, what are the specific charter rights under Sections 2 or 7 to 15 that are potentially engaged?
Thanks, Richard. So, I mean, the use of the notwithstanding clause at the beginning, that is to say preemptively, before there has been a court challenge, is designed really to prevent us from ever knowing whether these laws do infringe charter rights. But I think it's fair to say that in both these cases, there are charter rights that are at least engaged here. So for Quebec with Bill 94, the laicity extension law, I would say it's probably the same rights that we saw engaged with Bill 21. So that's freedom of religion, Section 2A, and equality rights, or the freedom from discrimination, which is Section 15 of the Charter. I think there's a strong case that those rights are engaged, if not infringed here. But as I said, the use of the notwithstanding clause preemptively means it's going to be very hard to find out. For Bill 2, we're looking at freedom of association. So that's a charter right to D, and that includes the right to collective bargaining and the right to strike now since 2015. And so Bill 2 engages both of those, right? Because it imposes a collective agreement, which seems to infringe the right to collectively bargain. If the government says, okay, no, here's the agreement, that wasn't bargained, right? And then the right to strike because it orders workers back to work. But as I said, this type of legislation isn't unheard of in our labor law context, because don't forget we have charter rights, but then these can be infringed if it is demonstrably justified in a free and democratic society. So that's Section 1 of the Charter. So typically, if a government wants to order workers back to work or impose a collective agreement, that does infringe Section 2D, but it could be justifiable in the circumstances under Section 1 of the Charter. So it could nonetheless be found to be constitutionally valid. Right? It's that second step of Section 1 analysis that will determine whether or not the law is valid or not. But the use of Section 33, as it's been used here in Alberta, using it before a court challenge even happens, is an attempt to bypass the court process altogether and say it doesn't matter whether it infringes your rights or not. It's happening anyway. So it's a way to circumvent the court process and the court recourse.
So I think you've touched on this already, but I want to talk in a bit more detail about the manner in which the notwithstanding clause was deployed in both Bills 2 and 94. Because I mean, if you look at the text of Section 33, all that seems to be required to use the notwithstanding clause is an express declaration in a legislative act, which is, clearly present in both of these recent uses. And yet we've seen criticisms in the media, not just directed at the laws themselves, but also at the way they were enacted. So maybe you could tell us a bit about these criticisms, and maybe you could tell us if they have any impact on the legality of these invocations by Quebec and Alberta.
That's right, Richard. The Supreme Court's been pretty clear in terms of the legality of an invocation of Section 33. All it takes is, did you use the appropriate words in the statute? And if you did, the court really doesn't have much else to say. That's the current state of the law. Of course, the Supreme Court will be asked to revisit this in the upcoming Bill 21 challenge. But as of now, that's the state of the law. It's pretty clear. But there's I would say maybe a normative issue happening here. And particularly, I'll take the case of Alberta in particular. It was done really, really fast. Um, and so the rationale for Section 33, it's often called like a democratic safety valve for the charter. So it allows the legislature to have the last word in the case of a disagreement between the legislature and the courts. Because why? Why is that legitimate? Well, because the legislature, unlike the courts, is elected by us, by the people. But in order for that democratic safety valve mechanism to work, the people, the voters, have to know and understand what's happening at the legislature. But in the case of when Alberta used it basically overnight on a Monday, it's used quickly. Debate was very limited. You really have to wonder whether it's able to serve that democratic safety valve function. Where is the reasonable disagreement? Did the public have a chance to weigh in on this? Have the public have the chance to tell their MNAs what they think? And why did it need to be invoked so quickly like that? I understand that ending a strike can be a very time sensitive policy issue that a legislature is dealing with. But as I said, a legislature has other tools to end a labor strike. And in fact, legislatures, end strikes a lot of the time using back to work legislation. It's always controversial when they do it. But most of the time they don't invoke Section 33. So I think there's something different about its use in Alberta this time. I think we see a premier who's reaching for Section 33 as kind of a power tool in her toolbox. And it's sort of the idea like, well, I have this tool, why wouldn't I use it? I can use it whenever I want. And I'll just point out the contrast with Peter Lougheed, who was the Premier of Alberta when the Notwithstanding Clause was put into the Charter, and he advocated strongly to have a Notwithstanding Clause in the Charter. But he wrote an essay in 1991, and he said, if I had to do it all over again, I would put three guardrails around the use of Section 33, and one of them would be that it wouldn't be used preemptively.
Thanks, Marion. So I know we've only got like 10, 15 minutes for this interview, but I do want to get up into some of the big, tough, existential questions around Section 33. We have seen a notable uptick in recourse to the Notwithstanding Clause in recent years, as you've already mentioned, and I think academics and lawyers are pretty divided still on where this leads us. So on the one hand, you've got folks who think that this is a natural, legitimate response to a spate of overreaching decisions by the courts, the Supreme Court in particular. And then on the other hand, you've got folks who think that this uptick undermines the idea of independent oversight of government, which is at the core of the Charter. So you've got a real clash of ideas playing out here in real time. And I'm wondering how you see the lay of the land here. I mean, is the clause getting progressively more normalized? Is it being used more assertively or maybe even more aggressively? Um, and if it is that an affront to the charter project, or is that evidence that the courts have been pushing the charter too far to the point where we're now seeing some legitimate backlash?
Right. So I would agree with the way you've characterized it as having sort of two schools of thought. I think it's important to remember the long kind of history of the Notwithstanding Clause that was used. Uh, it was used a little bit in the 1980s. There was a bit of experimentation with it. There was a big important period of use by Quebec in the 1980s. And then it really kind of peters out and it gets used once by Alberta in 2000, and then it doesn't get used at all for 18 years. Um, and then we start to see an uptick, one a year since 2018. So I call this the new age of the Notwithstanding Clause. Roughly once a year, and now 2025, we've had two uses in 1 week. So I'd say we're seeing it used now. It's a steady but maybe slightly increasing use. But we're seeing it talked about a lot more. We're seeing it being reached for and referred to more and more. And I agree there's two schools of thought here. One, okay, it's just the legislative response to decades of judicial overreach on certain things. And I think you can see that if you look at uses in isolation. If you look at only this use or only that use or only that use, you can find that the history of sort of the give and take between courts and legislatures on that particular issue in that particular place. But when I look at it overall, in the long, the long arc of history, I fall into the camp of, well, I think there's something bigger going on here. Um, and I think it's linked to the fact that many things in our Canadian democratic system really depend on political leaders acting according to certain unwritten norms and values. So all the conventions of responsible government, for example, there's a lot that's just expected that people will do because that's just the way you do things. And it depends on norms and values, democratic norms and democratic values. And I think the notwithstanding clause is one of those things and always was meant to be one of those things. And I say that because if you look at the bare words of Section 33, there really are no limits to its use whatsoever, except that it expires automatically after 5 years. But there's no limits in the words about what you can use it for, or how extensively you can use it. So it can be used, as it has been, to override freedom of association, freedom of religion, equality rights. Those are all things it has been used for in the last few years. But there's no reason in the words that it couldn't also be used to override, like, the right to be free from arbitrary arrest or unreasonable search or arbitrary imprisonment. Those are all charter rights that can be overridden by Section 33. Now, when I say that, people immediately react, well, it would never be used for that. That's preposterous. But I mean, 6 years ago, it was preposterous to say that it was going to be used once a year. That was unthinkable. So I don't take these things for granted. That's my point, though, that we have this sense of what's normal and what's not normal. It was norms, I think, that kept it from being used at all for 20 years. Now it's being used again. And so that's, to me, that's a sign that the norms are changing. Sort of, I think that Section 33 use is like the canary in the coal mine, for our democracy. It tells us that something is changing and we have to pay attention to that. So yes, I am extremely concerned that we're seeing it used more and more often. And I do think every time it is used, it becomes more normal and less newsworthy, as it's not newsworthy in Quebec anymore when the notwithstanding clause is used. And I think if that's happening, the public, isn't able to hold governments to account for using it. And then it just becomes more and more common. And I think it will undermine this, important legal protection that we all enjoy, which is our fundamental rights and freedoms.
Thanks, Marion. If I may, I'm going to squeeze in one more question. I'm going to try to keep it brief. Um, the question really is, how do you think about what's going on here? I mean, it seems like with so many recent invocations, there's something broader that's being contested or maybe even rejected by certain provinces. But if that's the case, how would you characterize that something? Is it certain pan-Canadian norms? Is it judicial oversight generally? Is it just specific judicial decisions? I mean, maybe this is a slightly more focused version of the previous question that I asked, but what really is going on here?
I would say overall, looking at all of these things together, what I see is a rejection of constitutional norms as a check on state power. So when I think about invocations of Section 33, when I think about things like the Alberta Sovereignty Act or Quebec's Bill 1, I see basically just a flouting of constitutional norms, in different places and for different reasons and in different ways. But I think the overall effect is, first of all, to diminish um, people's respect for those constitutional norms, and to sort of make it more normal to just push away at the Constitution and the rules that imposes on politicians, because the Constitution itself is a limit on political power and state power. And so we don't have to look very far to see politicians flouting constitutional norms and think about why they do that. And so when we see that happening in Canada, I think we should be very concerned and very vigilant about that type of thing.